Hi folks, I'm Huntsville, Alabama criminal defense attorney Andrew Siegel of Siegel & Siegel. Today's topic is what you need to know if you're accused of a first-time DUI. There's a lot of misconceptions about DUI, and I want to try to clear up some of those and tell you some of the basic things you need to know. In this little video, I'm going to cover some of the basics. First thing you need to know is that there are a number of ways that a person can be charged with DUI. And DUI is not just a driving under the influence of alcohol area of law. The other thing you need to know is that as an area of law, it is kind of like the Sahara Desert, and what I mean by that is that just as the sands of the Sahara are constantly shifting, the laws on DUI are constantly changing, and you really need to be aware of it. You shouldn't rely on this particular video as legal advice. You really need to talk to a lawyer right away if you are accused of a DUI. But that said, let me move on to some of the basic things, some of the things that you really need to know about DUI. As I've said, DUI covers more than just alcohol. You can be charged with DUI for marijuana, any kind of controlled substance, any number of things. Also, you don't even have to be driving to be charged with DUI. It can be for actual physical control of a vehicle. And I'm going to explain that in a minute. As I said, it also can be for driving with above a certain blood alcohol content, that is above 0.08 of alcohol in your blood, or any number of controlled substances or other substances. And what I'm going to do today is cover some of the 6 most common DUI categories, and we're going to talk about that in a minute. One of the things that I want to cover is that people are often surprised to learn that you don't even have to actually be driving the vehicle to get a DUI. And that's because the law says that if a person was in actual physical control of a vehicle while they were either intoxicated or under the influence, they can get a DUI. And by actual physical control, they look at the totality of the circumstances to determine if somebody was in control of the vehicle. That leads to what, at least in my brain, are some kind of odd results. Let me give you a real-life example. Some police officer comes across some guy, and we're not going to argue the issue that this guy is blitzed. He's intoxicated. He's behind the steering wheel of a car, and he's steering the car, and it's moving. Problem is, the car is completely non-operational. This car is broken down. It doesn't work. The only reason the car is moving is that there's a car behind him that is pushing this completely unoperational car. They're trying to push it to a gas station so that they can, whatever, get it out of the road, get it repaired, whatever. But the police officer arrests this guy for DUI. Goes to court. His lawyer says, "Judge, how can you charge this guy with DUI? This guy, he's not driving a car. He's steering an unoperational hulk of a car. There's no driving. He's just steering a dead car." And the prosecutor says, "No, he's driving a car that happens to be propelled by another car." The lawyer says, "Well, I'm appealing it," and he takes it up to the Alabama Court of Criminal Appeals. The argument is repeated. His lawyer again says, "That's not driving, that's just steering a car that's dead." What do you think? I can tell you what the Court of Criminal Appeals said. The Court of Criminal Appeals says, good enough for us. We count it as being an actual physical control of a car. We think he's guilty of DUI because he's in actual physical control of a car while he's under the influence of alcohol. Kind of makes me wonder, I mean, if the same guy had broken down, had an inoperational car, he's drunk, some Amish guy comes up and says, "Well, let me hook you up to the buggy and pull you to the gas station." Same thing. Cop comes along, arrests him. Would he be guilty? I would guess that from the Court of Criminal Appeals ruling that they probably would say, good enough for us? Yeah. Don't know. Now, the next question then is, well, what's a vehicle? There was a case in Alabama that I saw in the papers where a woman was arrested for driving under the influence while she was on a horse. is a horse a vehicle? I don't know. I didn't see how that case came out. I think there's a pretty good argument that you ride a horse and you don't drive a horse. That's certainly what I would have argued if I was her lawyer. And kind of a horse is a horse, of course, and it's not a vehicle. I don't know what the lawyers argued. I don't know how that case wound up. But these are the kinds of things that lawyers get paid to argue. Now, to get a little bit more back on target about the types of DUIs, one of the ways that people get charged with DUI is by having a 0.08 or more of alcohol in their blood. And this is what's called a per se law. It's almost like a speeding ticket. In other words, if the speed limit is 50 and you're going 51, it doesn't matter the reasons. Law says, hey, it's a bright line test. You're over the limit. Too bad. And this is an area of law that certain lawyers specialize in and do a terrific job at. There's some lawyers in town who have literally taken apart the breath testing machine and put it back together to know it inside and out. And for folks who have their, in this town there's people with security clearances and things like that, for folks who have their whole life riding on whether or not those test results are to be believed, that's a very important thing. But that is a per se law, and all the prosecutor has to prove in a per se case is to establish beyond a reasonable doubt that, yeah, it's above this limit, and if that's accepted by, whether it's a jury trial or a judge trial, if that's accepted, that can be all she wrote. So that can be an issue on a per se case. Now, the most common form of DUI that we see by far is a DUI where they're trying to establish that a person was driving under the influence of alcohol, where they're trying to establish beyond a reasonable doubt that the person was unable to safely operate that motor vehicle. And that's, like I said, probably 80% of the cases that we see. They can use the blood alcohol content in that kind of a case, but they're not relying exclusively on that. So that's a very common, we see that all the time. The next type of DUI charge is and I'm not going to, by the way, I'm trying to keep this video short, so I'm not going to go into all of the defenses that come up in all of these different types of charges. This is just an overview of the kinds of charges. Another type of DUI charge is when an individual is charged with driving under the influence of a controlled substance to the degree that that controlled substance renders them incapable of safely driving. My view is that these can be difficult cases for prosecutors in many instances, particularly where there is no other evidence other than the testimony of the police officer. Because, if there's not urine or a blood test, how do they establish this? The breath test doesn't test for other substances, so unless they've gotten some other proof, usually these cases, for them to be successful, either they found some sort of controlled substance, maybe some marijuana in the car, or there's a statement by the accused or something of that nature, oh, gee, officer, I just finished smoking some weed, and I drank a half pound of, I drank half a bottle of vodka or something, or there's a bag of marijuana or whatever. So those kind of cases, they can be difficult depending on the nature and facts of the case. Fourth type of DUI is a combined influence of alcohol and a controlled substance. Again, many of the same problems present. The prosecutor has to establish beyond a reasonable doubt that the person was under the influence of both alcohol and some form of a controlled substance. Fifth provision, or the fifth type of DUI, is what I call the catch-all provision, and that's that somebody was under the influence of some substance, some form of substance, that impairs their mental or physical facilities to the degree that they are incapable of safely driving. I haven't seen many of these cases. I did see one as a prosecutor where a guy was charged with driving under the influence of paint. The guy had a bunch of cans of gold spray paint in his car. He had a plastic bag that had spray paint in it, and around his face and his lips in particular, he had gold spray paint. He was hiring a kite. He was a paint hacker, and it's pretty easy to prove that case. We were able to establish that, yeah, he was driving under the influence of paint. He was convicted. The sixth provision is what we lawyers call kiddie DUI, and basically the law says that if a person's under 21, there's essentially a zero tolerance policy. If you have between 0.02 and I believe 0.08, you're not supposed to have any alcohol content in your system, and there are specific penalties for young people who drive with alcohol in their blood. If they're above a certain level, if they're above 0.08, they get treated like an adult, and they have the same consequences as anybody else. Or I need to backpedal, they may face. There's Youthful Offender Act and other things that can be done. At any rate, probably the most important thing that you should realize if you're a first-time person or a loved one is accused of a number 1 DUI is that there are a number of things that can be done to avoid a conviction. Even if you're 100% guilty, there's a number of things that can be done to avoid a conviction. And that's because under certain circumstances, your lawyer may be able to negotiate with the prosecutor to allow you to participate in various kinds of programs to avoid being prosecuted. You have to understand that there are a variety of programs, and they vary from court to court. And not only do prosecutors, but judges have their own different views, and each case is fact-specific. And so we can't tell you right off the bat, I certainly can't in the video, whether you qualify or not qualify. There are certain judges who may not approve something, and there may be workarounds for that, where if we do this or we do that, we may be able to reach an alternative resolution that in the end gets the person what they want. All of these are things that you need to talk to your lawyer about. Clearly, if you want to talk to us, give us a call at Siegel & Siegel. We're happy to help. With us, your first consultation is free. We don't believe in charging for a first consultation. I hope that this video has been helpful to you. It's meant to be educational. If you want to give us a call, our phone number is below, and thank you for watching.